talk about preventing sexual harassment in the workplace, along with general anti-harassment and anti-discrimination policies and procedures to go. About 2 years ago, the Illinois General Assembly enacted a law that all employers, no matter how big or small, need to give sexual harassment prevention training. So that is why we are here. And so the Illinois General Assembly finds that the tolerance of sexual harassment has a detrimental influence in workplaces by creating a hostile work environment for employees. It reduces productivity and it increases liability as well. And importantly, it can have lasting effects for the individuals who are the victims, the park district, and the community as a whole. And this can include psychological trauma and stress-induced symptoms for the victim. It can create a hostile work environment both for employees and for the victim and general employees as well, especially those who may have to participate in an investigation. It can damage reputations, lead to negative publicity, civil liability, and depending on how serious it is, even criminal charges. So as a result, the Lamont Park District cannot take sexual harassment lightly. There's a couple of federal laws in place where sexual harassment has been recognized. It is a form of discrimination and it is therefore illegal. A couple ones to highlight are Title VII of the Civil Rights Act of 1964. This prohibits employers from discriminating against employees on the basis of sex, race, color, national origin, and religion. And it typically applies to employers with 15 or more employees. And we also have the Equal Pay Act of 1963, which protects men and women from sex-based wage discrimination in the payment of wages or benefits who perform substantially equal work in the same establishment. And then turning to a couple Illinois laws, the main one here that we'll focus on today is the Illinois Human Rights Act. And this prohibits sexual harassment in employment. It's a civil rights violation for any employer, employee, agent of any employer, employment agency, or labor organization to engage in sexual harassment. And that language is taken directly from the statute. And one of the department's roles is to investigate the charges, which are formal complaints of discrimination, including allegations of sexual harassment in employment. And a charge must be filed with the Illinois Department of Human Rights within 300 days of the incident. So that's important to know, especially for any victims who need to be documenting or to keep this in mind. It is a significant increase. A couple years ago, it was limited to 180 days, and that was a recent change about 3 years ago. And then the next law is the Illinois Workplace Transparency Act. This expands definition of discrimination and harassment to prohibit actual or perceived discrimination and or harassment based on the Illinois Human Rights Act's protected characteristics. So it does not matter what the intent is very specific on incorporating what perceived discrimination and harassment can be. And as a result of a couple of these acts and just new issues that have arisen in employment in the last several years globally and in Illinois and nationally, employers are now required to provide the annual sexual harassment training. So what is sexual harassment? It is defined as any unwelcome sexual advances or requests for sexual favors or any conduct of a sexual nature when submission to such conduct is made either explicitly or implicitly a term or condition of employment, where submission to or rejection of such conduct by an individual is used as the basis for employment decisions, such as pay raises, pay decreases, and increase in benefits of any kind, or such conduct has the purpose or effect of substantially interfering with the individual's work performance or creating an intimidating, hostile, or offensive work environment. And it's important to note, and we'll talk about this later too, but the phrase working environment is not limited to the physical location an employee is assigned to perform. So this can include having to go on assignment somewhere, or having to go to a vendor's office. And this is also probably going to come more into play now with the pandemic as more and more people are able to work remotely as well. And there's two types of measurable behavior in workplace settings for sexual harassment. The first is quid pro quo, which is you do something for me and I'll do something for you. It essentially means this for that. So a manager or a supervisor can't tell a subordinate that for them to receive a promotion, a better assignment, more vacation time, or to avoid something negative, such as discipline or being transferred or demoted, the subordinate must then do something sexual in return. The other type of sexual harassment is hostile environment. And this is when the issue at work is debilitating, it's impacting the individual, it's interfering with the person's ability to do work. And this can occur when unwelcome sexual advances or any kind of conduct of a sexual nature has the purpose or effect of interfering with the work performance. So the first type, that's quid pro quo, this is something that's given or withheld in exchange for something else. This is less common than hostile environment harassment, but this is typically what most people think of. And, oh, sorry. And it's tangible employment action against the victim or any type of monetary loss or change in job. And this occurs when there is a power imbalance between the two parties. So one person who's typically a supervisor or someone with some type of power to grant or deny benefits is sexually harassing someone else and has that ability to change or affect their benefits at work. So one example is a supervisor tells a subordinate that he'll give her a better schedule if she will go on a date with him. And then in hostile work environment, this is the unwanted sexual or gender-based behavior that creates a hostile work environment, and this can substantially interfere with a person's employment. So a very common example these days is sending offensive emails or text messages. And when it's important to be aware of these issues, people might find the content to be very humorous. 99% of the people can laugh, they can forward it to other people. It might not be funny to everyone, and certain people might not have the same humor environment harassment. One, it can include, it can occur, sorry, this, if anyone has the internet or if my internet's going in and out, please let me know. This can occur at all levels of the organization, involving administrators, supervisors, coworkers, and even contractors or vendors. Both forms are illegal. And in both types of harassment, gender does not matter. Males can harass males, females can harass females. The gender of the harasser and the victim does not make a difference. And sexual conduct can become sexual harassment when the behavior is unwelcome or unwanted. Behavior can be unwelcome in the sense that the victim does not solicit it or invite it, or when at one point it was funny or it was consensual and then it suddenly crosses a line and becomes unwelcome. Consent can be revoked at any time. When someone is experiencing sexual harassment, they can say, "Stop talking to me like this." They can say, "This is making me uncomfortable," and the individual must stop. Using the defense of, "Well, you started it," or, "Well, you were laughing," or, "You were okay at first," those are not defenses to sexual harassment, and that's important to understand. Even if the other person who is stating that they are a victim of sexual harassment was the one who started it, if suddenly it escalates, you can't then use that as a defense. So now we're going to look at a couple different types of sexual harassment behaviors. The first is verbal, and then we'll talk about nonverbal, and then we'll talk about physical behaviors. So a couple examples of verbal sexual harassment include threats or bribes for unwanted sexual activity, sexual or derogatory comments and innuendos, jokes or rumors, suggestive sounds, offensive graffiti, letters, notes, telephone calls, more in particular now in the news, a lot of emails, text messages, posting on social media is another one to be mindful of, and then deliberate touching, leaning, or cornering someone so they don't feel that they can get out of that situation. And nonverbal harassment can include ogling or leering, pointing or winking, suggestive gestures, facial expressions or bodily movement, or humiliating or degrading images of a sexual nature, including altered photos or video clips of some kind. And then physical harassment can include touching, groping, patting, squeezing, tickling, snapping a female's bra, pulling down someone's pants or shorts. And these all seem like they're obvious examples, but they do happen. And that's why we are working on giving this prevention today. And then I know I touched on it a little bit before, but gender is irrelevant. The harassing behavior may be someone of the opposite gender or by someone of the same gender. And it's also important to note that the victim of sexual harassment does not have to be the person that the behavior is directed towards. Anyone affected by the conduct can be a victim, such as someone who's walking by and overhears people joking or making comments, even if it's not directed at them. So that's important to note, especially in an office setting when you don't know who all is hearing, you don't know who might be offended, and you don't know how any perceived joke might be perceived by others. So turning to the working environment, this is not just the physical location where the employee is assigned. It can extend to office locations, it can extend to remote work, off-site places, or moving work locations, including off-site events. And it's also not limited to coworkers and supervisors. Patrons, vendors, delivery people who come into the workplace and interact with employees can also be victims of sexual harassment. And those non-employees can also violate sexual harassment laws as well. And looking at the role of the courts now to determine what is hostile or abusive environment, the courts typically look at all of the circumstances. The magic phrase is the totality of the circumstances. And this includes the frequency and severity of the conduct, whether it is physically threatening or humiliating, and whether it unreasonably interferes with an employee's work performance. Courts also consider the reaction of a reasonable person in the victim's position. So neither someone who takes everything as a joke or someone who's offended by everything. They look at what a reasonable person would think. And a single severe incident can itself constitute sexual harassment. For example, groping a staff member can be enough to create a hostile or abusive environment, even if it just happens one time. However, if the conduct is less extreme, such as an inappropriate joke, then the courts would require that the victim show a pattern of repeated, routine, or generalized harassment. Factors that courts consider also include whether the conduct was verbal, physical, or both, whether the alleged harassment was a coworker or a supervisor, and this can also create an issue as to whether there was a quid pro quo issue, whether other people joined in on the harassment and led to an increased level of embarrassment and some type of public issue, and whether the harassment was directed at more than one individual, such as if a specific person was targeted out. And there's a few EEOC remedies that are important to note for sexual harassment or gender discrimination too. And these include job reinstatement, back pay and benefits the victim should have earned, compensatory damages, punitive damages, which are punishment, and liquidated damages, which would be equal to the amount of back pay awarded to the victim. It's also important to note that if you are a victim of sexual harassment or you are a witness and you participate in an investigation, retaliation is also illegal. And this is any adverse action taken against an employee, whether they are the victim or a witness, because he or she complained of harassment or discrimination or participated in an investigation. And this can include a demotion, a discipline, termination, any negative performance review or change in benefits or job duties or a shift assignment, any type of change in vacation time, that would all constitute retaliation. And there's a couple Illinois laws that prohibit discrimination or employers from taking adverse action. And this includes the Illinois Human Rights Act, which states that it is a civil rights violation to retaliate against someone who's opposed that which he or she reasonably and in good faith believes to be unlawful harassment in employment. And we also have the Illinois Whistleblower Act. So when an employee complains of sexual harassment to a supervisor, administrator, or anyone at the park district or other government agency, such as the IDHR or the EEOC, action cannot be taken against that employee that the employee may view as punishment or retaliation. And to succeed in a retaliation claim, the employee must prove that he or she engaged in a protected activity, such as complaining of sexual harassment or participating in an investigation, that he or she suffered an adverse employment action, such as a demotion or a negative benefit, or that the protected activity and the adverse action are linked. And that's why it's important both for employers and employees to make sure that they document. Documentation is very important. And turning to how to report sexual harassment, there's a couple different avenues that we'll talk about tonight because the choice is very personal and the options are also not mutually exclusive. You can report to the EEOC, you can report to the IDHR or to your employer, you can pursue one of those avenues or you can pursue all of those avenues. And the first is you can also call the State of Illinois Sexual Harassment and Discrimination Helpline if you are not sure which one to choose or if you just need to talk to someone to get questions answered or to get some helpful facts. You can go to this number or visit this website, which is through the State of Illinois, or you can report the incident to the Park District as well, which we'll touch on down the road looking at the Park District specific policies. And this is the information regarding the Illinois Department of Human Rights. Their main office is in Chicago, but they have an office in Springfield, and they also have an office in Marion. And then this is how to contact the EEOC, which is the Equal Employment Opportunity Commission. And they have an office in Chicago and an office in St. Louis. And one of the final things as we're talking about reporting sexual harassment is that you need to be mindful that making false reports is also illegal. Allegations of sexual harassment are very serious, and employees should not bring false accusations of harassment. If it's determined that an employee has made an allegation of harassment that he or she knows is false, then disciplinary action up to and including discharge can result to the employee who made the false or the bad faith allegations. And employers are strictly liable for sexual harassment that's perpetrated by its members of management, regardless of whether the employer knew of the harassment. And employers are liable for sexual harassment perpetrated by a coworker or a vendor only if the employer knew or reasonably should have known of the harassment and failed to take prompt corrective action. Looking at the Park District specific policy, there's a couple different steps that you can take, and it's also in their written out anti-discrimination policy or anti-harassment and discrimination policy. Step one is that if you're comfortable, communicate directly with the offender and express your objection that the conduct is unwelcome and offensive. We do acknowledge that it is very difficult sometimes to tell a perpetrator that their behavior is uncomfortable, but that is always an option. Step two is to document each incident of alleged harassment. This is very important and to include the date, the time, the place, what was said or done, who was there, who may have heard, and the surrounding circumstances. And then to bring the attention to the department head, or if they're unavailable, the executive director. If the executive director is the source of the problem or condones the problem, then that next step would be to contact the president of the Board of Commissioners. And then the Park District will investigate the complaint as promptly and thoroughly as possible and in accordance with the handbook and with state and federal law. All complaints will be kept confidential to the extent possible. If investigations proceed, then witnesses may need to be called, and depending on the situation, the victim may need to participate in that investigation, but all complaints will be kept confidential to the extent that it is possible. And looking at a couple action steps in order to develop a no tolerance culture is to educate yourself and others on the signs of harassment. So that is reading the handbook and also paying attention to presentations like these. Speaking up to harassers if you are the victim or you're witnessing something, and speak to a supervisor or department head. Listen, cooperate in the investigations. If you are not the victim, and you are a witness or you are a party to an investigation, maintain confidentiality to protect all the parties involved, including yourself and the victim. This is a very sensitive topic, so you want to keep everything to confidential to maintain the integrity of the investigation. And then lastly, reviewing the handbook regarding the non-discrimination and anti-harassment policies. So a couple takeaways from today: review the policies in the handbook and remember that intentions do not matter if a person feels harassed. What may have been an innocent joke to you could be perceived to be offensive conduct by someone else, because different people do have different reactions to the same behavior and could have very different interpretations. And lastly, harassment can be from an employee or non-employee. And again, the working environment is not specific just to where your specific office is. So going forward, if you encounter any form of sexual harassment, the problem should be brought to your supervisor or department head. All complaints will be kept strictly confidential to the extent possible. Any questions concerning sexual harassment should be directed to your department head or supervisor or the executive director. And then I just included one last time the information for the Illinois Department of Human Rights, because all employees have the right to contact the department and the EEOC as well. So that is the end. Hopefully that was short and simple. And if anyone has any questions, please let me know.